Heather signed the consent form for an iPhone 5 model blank with an MEI.
iPhone 5. Oh, I need something as an example. What would be an iPhone 5 sitting on my desk? It would be something like this. This would be like an iPhone 5. Oh, hello? I don't even remember. I never even had an iPhone when they were phones. Yeah.
Furthermore, before the court issued its order, which I think we are.
Yeah, but you lied. You lied about discovery. You lied about what you had when you had it. Doesn't matter that discovery hasn't been filed, that they don't have all the discovery. It's an ongoing investigation. You fucking lie. Hey guys, welcome back to the bars. I am Sam. So good to see you guys. Man, I am so excited. I'm going strictly off the cuff. No script. Well, I never have a script, but I'm going strictly off the cuff because I found this video. I want to show it. It's more Alan Jackson. You know how much I love Alan Jackson. You know, I started this whole YouTube journey doing legal court, true crime, trial after trial, docket after docket for 2 years, just, streaming the daily dockets every day, commenting on trials, doing commentary. And you know that I have like this huge, man fanboy crush on Alan Jackson. Anyways, I'm just like, my wife's out at a birthday party, and so I'm just at home watching YouTube, working on a new channel that I'm doing with some true crime stuff. And bam, there's Alan Jackson and Kevin Spacey in a trial from 2019. Well, what almost came to trial. I don't want to give too much away, but I am so excited to watch this with you guys. I'm so excited to do commentary on it and to share it with all my Karen Reed lover supporters out there. The Justice for John O'Keefe stuff that we got going on, but this is just more Alan Jackson that we can enjoy. And let me tell you, this is 6-7 years ago, and now we know why he is the man, because this is even then. Kevin Spacey was falsely accused, and we'll get into all of that at the end. This might be a 2-part special because I want to cover a lot of it, and I don't know how much I'm going to flip my jibs regarding it. And guess who's with him? That's right, Elizabeth Little's with him. So that was exciting. So let's get to it. For no further ado, let's watch a little bit of this bad boy in action. First, it's going to show a little bit of a preview, and then we'll get to the couple of main events.
If it wasn't Mr. Spacey, you never would have filed the case? Is that the translation?
I think you've had way too many questions that have gone way too
listen
far.
to me. You keep this up, I'm going to hold you in contempt. This is a criminal proceeding, and you will cooperate.
Oh yeah, and this is in Nantucket, so they got that that Massachusetts, that East Coast, Upper East Coast, New England accent, so that makes it badass also.
Or as I say, you'll be held in contempt.
I understand.
When did you first notify the police about these allegations that you've made? About 1 year and 3 months after the event.
Yes.
I mean, you didn't go to the police the next day,
No.
the next month.
No.
You didn't even go within the next year, did you?
I don't believe so.
This case needs to be dismissed, and I believe it needs to be dismissed today.
The data that she told me she authored had to do with frat boy activities.
And they actually objected to us getting the phone. It's outrageous. How could they conceivably do that knowing what they knew? If the allegations are untrue, every bit of data is relevant, ma'am.
The allegations are not untrue.
We'll see. But if she's gone through and scrubbed that phone to make him look like some sort of choir boy, and Mr. Glennie already knows, and he should be concerned that his extraction report is inaccurate, because that's the big issue in front of the court.
I believe I was raised to tell the truth and not be afraid to.
This is big, bold, new news.
Oh my gosh.
It's new to us. It's new to the court. The problem is it's not new to them. You remember giving a press conference,
Yes,
obviously. What's on the table? The next one.
beer cans. It doesn't make him a criminal.
I didn't ask you if you made him a criminal. I think it's outrageous. I think it's unjustified.
It's the
and it's not
accuser's
fun.
mom.
Did you have a conversation with your wife at any point between then and now
No.
about, well, let me finish my question.
I know what your question is. Go ahead.
Well, you don't know what my question is. I don't make these points lightly. It is not fun for me. This is not enjoyment for me.
I've never done
It
it,
is.
so I don't know.
Bless your heart, me neither. Wouldn't want to. But that's what he's doing, correct?
Well, I can see some deleted items and I can see things that basically weren't deleted that looked like frat boy activities. So my first thought was probably not the best job of deleting things.
Period. Full stop. Well, she's not in the room now, I hope. She's the only one
Yeah,
among us who knows what those, quote, frat boy activities are. Trooper Donovan certainly didn't.
The reason for Venmoing you this money is, and someone would say prostitution. I said, what the hell is this?
And then you deleted it.
I don't know if I deleted that. No. Let's be clear about something. That was later. That was later. He was getting high. He had a water pipe of some sort and he was getting high.
He told
Dude, Kevin Spacey is awesome. Huge fan. Yeah, he's a perv. He's admitted, he's gone on podcasts since all this has been dismissed. And they, after they canceled him, he came back out and he's just like, I don't want to be uncanceled. He's like, yeah, I flirt with younger men, but I don't flirt with underage men. And, and yeah, if I've come on to people that, I've known to be homosexual and because, we do the secret handshake or whatever. And, the double winks, handshake, skirts, whatever homosexuals do. Right. And I know it's not that, but, all my gay friends tell me that, they have like this look and like this double stare that they do. And I'm like, oh, badass. I go, that makes it easy. But anyways, and Kevin Spacey's just been a badass about the whole thing. And so when I see him laughing with Alan Jackson, it makes me happy because he knows this is the beginning. He knows he's not worried. He's like, he knows that the truth is going to set him free, not their truth or our truth. The truth is going to set him free, and he's not worried. Plus, he's got the best lawyer in effing town.
an officer of the court, me, something that he knew to be completely false. That was a blatant falsehood.
Looking at what's in the phone, or are you talking about what's happening in the real world of what's happened here?
Are you kidding?
The phone was not the issue.
Let me finish. It'd be one thing if all of us were fooled by the Unruh family. The Commonwealth wasn't fooled. They had all this information. If the court could accommodate us in August, even late August.
No, it can't. It's difficult enough to get accommodations on this island. Well, it would be impossible to get this case
I'll
tried.
stay in a tent.
Well, I'm glad to know that. But,
I get accommodations or lax, but we'll make do, Judge. The horse is, if it's not dead, it's on its last leg, and I don't want to beat it.
consider the horse dead with respect to a trial in August. So
I was hoping you weren't going to say that. This is a ridiculous case, and they shouldn't have filed it to begin with. But they did it. They unlocked that barn door, and now the horse is out, and they've got to go to trial.
Look, private jet. That's our boy right there. That's our boy. And that was 2019. Yeah, he was a beast. He was a beast. Okay, that was some previews. So we're gonna start with the first arraignment.
with the alleged victim. All right. I know there was a motion filed by defense. I had occasion to look at
talking
it.
about
Mr. DA,
restraining
you had occasion to
orders.
look at it?
We've reviewed them, yes, Judge.
Okay. You want to be heard on the motion or?
Briefly, Judge, regarding the motions to preserve, we agree that anything that is currently in our custody and control, we have to preserve, we will preserve, and we will turn over in discovery.
Sure.
As it relates to the motion to preserve itself, we're suggesting at this point that the scope that is being requested by counsel is overly broad. It's asking for July 7th and July 8th of 2016, but all the way up to the present. We
Right.
suggest that based on what's been filed up to the present is overly broad. The affidavits in the motion suggest that Mr. Little and his girlfriend or another individual were texting contemporaneously on the 7th into the 8th.
Yeah, so says you. But all that shit's been deleted. Let's just get to Alan Jackson's argument. These are just motions, and and stinkerdoodles. We'll just call them stinkerdoodles. But let's get to some Alan Jackson action. Action Jackson in action.
We would suggest that it's a fishing expedition at this point, and that the motion should be narrowed at least to the 7th and 8th of July of 2016.
It's a fair point. Mr. Jackson or Ms. Bolero, I don't know who's going to respond, but feel free.
I'll be happy to respond, Alan Jackson, on behalf of Mr. Spacey.
Sure.
Your Honor, I don't believe at this point that we need to talk about the scope. That's something in terms of a subpoena. In other words, what I subpoena or what I serve on those individuals might require a discussion or some litigation about the scope. All I'm asking at this point is that we preserve it. In other words, this is data that we believe is not only potentially exculpatory, but likely exculpatory for Mr. Spacey. I simply don't want to see any of that data deleted, destroyed, even inadvertently, or in other words, in any other way manipulated. I don't think it's a burden at all on the Commonwealth, nor on the two individuals named in the motion, MD and the complaining witness, to simply say, I'm ordering you not to destroy anything, so that Mr. Jackson, Ms. Bolero, the Commonwealth can litigate in front of the court at some point whether or not there is exculpatory information that leads all the way up to today. In other words, all I'm asking for is just to put a bubble around that data so it doesn't get destroyed. I'm not saying I did it yet.
He's a beast. Him saving that option for that exculpatory evidence, to be able to argue it, to defend his client is amazing, for the exact reason, for what we're about to find out in the at the next hearing. They're just talking about fun stuff, and then here we go. Here we go.
We're all rise. May be seated. Thank you.
Folks.
Morning, Your Honor.
This is Commonwealth versus Kevin S. Fowler.
Okay. Gentlemen, thank you. I reviewed the pleadings. Mr. Glennie, I haven't had a chance to go through your response
right here
completely, the exhibits, et cetera, some of which I'm familiar with, others I may not be, but we'll go forward with the arguments. And my hope is that I am here all week, so I will issue a written ruling on this matters, and hopefully that can be done this week if the jury trial is scheduled to break down and give me a chance to do that. As I said, I've looked at the pleadings. I'm also aware that there was a protective order that apparently has been signed by the parties. I don't know whether that was signed this morning or it's not dated, which seems to, I guess this applies to the extraction completed by the Commonwealth of Mr. Little's phone. Is that right?
Yes, sir. My understanding is, I don't know when, but they brought their signed portion of it today.
Sure.
We signed our portion today.
Okay.
So when they signed it, I don't know, but it was signed for the court today.
So is this copy that I have the one that both?
I'm just going to say right away, because this is kind of dead, but we need to get through this, is that Alan Jackson is worth every single cent that he gets paid to do these, to handle these cases. And he absolutely chews up this Commonwealth, chews them up. He must love coming to the East Coast. He has to love it because he keeps doing it.
Both parties have signed?
Yes.
That's right.
And is it both your desires that I endorse this and this become the protective order that it's going to apply in this case?
So submitted.
Yes?
Yes.
Okay, I'll do that and I'll date it today. Mr. Jackson, you're still going forward on your request for a forensic download performed by your expert of the phone itself. Is that right, sir?
Correct.
Okay, and I think I saw, Mr. Glennie, in your response that the phone has been turned back over to either Mr. Little or his mother. Is that right?
That is correct.
Can you tell me when
Unbelievable.
did your office complete the extraction in this case?
I believe it was in November.
And when was the phone turned back over to?
November.
Actually turned back over in December of 2017, December 18th, 2017, which we've just learned. So they had the phone, the actual physical phone, for a little better than 2 weeks, 2.5 weeks or so.
Okay. All right. So the phone was turned back over to the owner in advance of the case being filed and any orders that I issued pertaining to preservation of evidence.
Seeing her there.
About a year and a half in advance.
Okay. All right. I understand. All right. Why don't we proceed? And Mr. Jackson, if you want to address me concerning your requests,
Here we go.
I'm happy to hear you, and then I'll hear, Glennie, your response.
Your Honor, there's 3 or 4 points that I want to make broader on a broad scale, 3 or 4 points that I want to make today. And I want to start with probably the most troubling. There are several troubling aspects of what's been going on up to this point, but the zenith of those is misrepresentations that were made by the Commonwealth to the defense, very specifically as they relate to Will Little's phone. Just to go back and to cover some dates, January 14th, 2019, that was the date that we, the defense, requested any and all relevant information related to Will Little's phone. We requested the phone itself or access to the phone itself. We requested any extraction reports. We requested any information attendant to that phone. On February 22nd, 2019, the Commonwealth, through their representative, falsely denied having any access to the information on the phone and to the phone itself.
This is unbelievable.
That was a clear and intentional false misrepresentation and falsehood that was designed to keep us from knowing exactly what the Commonwealth had in their possession. It is inexcusable. The Commonwealth has taken the position, and they're parsing words and trying to be, I think, too cute by half. They're now taking the position, well, hang on a second. What Mr. Giordino was responding to was his physical access to the phone, not the information surrounding the phone. He said he didn't have the phone, which was true. He didn't say he didn't have the information to the phone. That's not what he was requesting. Well, the Commonwealth knew exactly what we were asking for. We weren't parsing words. We said we need access to the phone and the information on the phone. Why? Because we think that it contains potentially at that point, and now we know it's true, exculpatory evidence. So to parse words between were you actually asking for the physical phone or were you asking for the information attendant to the phone, that is a non-starter. And it's a little bit of a desperate attempt on the Commonwealth's part to cover their tracks, as it were. But in point of fact, he's even wrong about that. Mr. Glennie, in his moving papers, which I just received this morning, indicated, well, what Mr. Giordino said was, we don't have access to the phone. He wasn't talking about the information on the phone. So now let's parse those words out and talk about something else. This is our actual request. Number one.
Yeah, did they think he wasn't going to have the actual request? Like, oh no, we thought you meant just the phone. It's bullshit. They know exactly, like, we meant the phone. We meant any extraction reports that you have. It's told when he says too cute by half, that's what he means. He's like, no, he thinks we're idiots. We're not idiots. This is Alan Jackson, Elizabeth Little, dude.
One, in a January 14 letter, 2019, we request the following information. Number one, the cell phone numbers, carrier information, passcodes, authorized users on the accounts associated with any cell phones used by.
And we all know Elizabeth Little keeps notes. She keeps massive notes.
William Little between July 7th, 2016 and present. Thereafter, there was a meet and confer on February 27th, 2019. So about a month and a half, 6 weeks after this letter was sent, there was a meet and confer by Miss Elizabeth Little, my associate in my firm, and Mr. Giordino. That was a telephonic conversation. Ms. Little took contemporaneous notes and holding those notes. Number one, in response to that request, Mr. Giordino's response, quote, investigator does not have this information, not in the care, custody, or control of the government. That was a blatant falsehood. They knew they had it. They had had it for a year and a half. They took the phone on November 29th, 2017, and they didn't give it back until December 18th, 2017, during which time they did apparently a full forensic download, I expect that they're going to say, and they did a forensic extraction report. And all of that was hidden from us from January 14th until basically present. On April 4th, if the court remembers, we were back in court in front of this bench on April 4th. 2019. At that time, the court was going to rule on whether or not we got access to William Little's phone. You'll recall that.
Mr. Giordino indicated he had some of the information you were looking for. He was going through it, right?
And on that date, I was sitting in that bench right there, the first row. Mr. Giordino was standing just inside the bar. After having received the partial report.
Now, and because he can talk about this like conversation that he had with like another investigator off the record, because he's an officer of the court, of course. And that's why he can, it's not hearsay. It's not anything like that. He's an officer of the court, so he can relay a conversation that he had.
That he gave us. I'd flipped through the first 4 or 5 pages, and I looked up at Mr. Giordino and I said, Mike, I'm troubled by this. Why is it that we're just now finding this out? You had this information for apparently a year and a half. And his answer to me was, my apologies. I owe you an apology. but there were people in my office who believed that it was better if you didn't know that we had the phone until I've had a complete opportunity to go through it. That is absolute outrageous, and it should never, ever happen in a court of law. He told an officer of the court, me, something that he knew to be completely false, i.e., we don't have that information, we don't have the phone, we don't have access to it. And Judge, just to bring this full circle, that representation was the foundation on which we, the defense, ended up filing motion after motion, litigating issues in front of this court, wasting the court's time, wasting our time, wasting my client's time, my client's money. This was a concerted effort to keep information from us that is unjustifiable. With regard to the information, if Mr. Glenny's position is, well, he never said he didn't have the information, there is a report that we finally got after April 4th?
April 4th.
After April 4th, we got finally, in the tranche of information that we got, was a consent form. Remember, the request that we had made.
Consent form signed by
Heather Unruh.
Ms. Unruh, yeah.
As it relates to Will Little's phone. Remember, just to remind the court, what we asked for was cell phone numbers, carrier information, passcodes, authorized users, etc. This document shows that as of November 29th, Heather Unruh provided all of that information. There's an EMI code.
2917.
Yes.
2917.
That's right. November 29, 2017, they had in their possession this consent form, which has Heather Unruh's name on it. It has Trooper Donovan's name on it. It has the EMI code for the phone. It has the user information, Will Little, Heather Unruh. It's got the passcode, which I won't name in court. It's got a signature via Heather Unruh, and a date of November 29th, 2017. So the Commonwealth doesn't get to parse these issues out and be too cute by half by saying, well, we said we didn't have the phone. We never said we didn't have the phone. What we said was we didn't have the information, or vice versa. They had both. They had access to both. We then get a new report this morning, which is, I thought I couldn't be more troubled by the conduct of the Commonwealth to date until I was handed this report 20 minutes ago.
Was this part of Mr. Glenny's filing?
This was by Mr. Glenny. No, I don't believe it's part of a filing. I believe Mr. Glenny just very kindly handed me the report this morning, indicating that it had just been done. Trooper Donovan was asked, I guess, by Mr. Glenny or Mr. Giordino or somebody in the Commonwealth to synopsize his recovery of and possession of the phone, because that's the big issue in front of the court. In that synopsis, which is only about 3 sentences long, for the first time ever, Trooper Donovan reveals the following, and I quote, "On Wednesday, November 29th, 2017, Sergeant Scott Brightman and I went to blank address. I believe that's a home address. I will not name it out loud. To meet Heather Unruh in order to gain written consent to access William Little's phone. Heather signed the consent form for an iPhone 5 model blank with an MEI."
iPhone 5. Oh, I need something as an example. What would be an iPhone 5 sitting on my desk right now? I don't know. It would be something like this. This would be like an iPhone 5. Oh, hello. Oh man. I don't even remember. I never even had an iPhone when there were 5s. Yeah, that's crazy.
Code of blank. Heather said Will had a new phone, but the phone she was giving us was the iPhone Will had in his possession July 7th to July 8th, 2016, while working at the club car on Nantucket. And here's the revelation. Quote, "Heather informed investigators she had gone through the phone to remove anything related to what she described as Will's frat boy activities." Are you kidding? Heather?
Yeah, that's the mom. That's the mom of the accuser. So they gave her back the phone, and she said, well, I just took out his frat boy activities. But to hear the trooper tell, and I haven't seen all of this, I just checked it out bits and like minuscule bits and pieces, then came right on to do a pre-record, is that she didn't do a very good job of that. So that tells me that she deleted other things that weren't so much frat boy activities. She just used that as an excuse. At least that would be my theory. And I'm sure that's going to be Alan Jackson's, but I'm only guessing. I haven't heard him say anything like that. But yeah, let's get back to it.
Unruh took it upon herself to physically remove exculpatory information from the phone before she handed it to the government. And the government never told us that had happened, nor did they take the very normal step that you would expect the agency to take, the police agency to take, which is to do a full extraction and recover those deleted texts. Why is Heather Unruh the holder of the keys? Why does she get to be the gatekeeper of information that is propounded to the government or, more importantly, to us? She isn't, and she can't be. It's completely inappropriate.
Can I just stop you for a sec?
Yes.
You indicate that the Commonwealth and the Commonwealth admits that it did an extraction. So when you have if you don't have it, you will have it soon. The benefit of that extraction per my order and per agreement. With that information, can your expert resurrect those deleted items? Or?
No, that's the second point that I wanted. That's a great segue. That's the second point that I want to address to the court. And I will explain right now why that can't be done with, let me see the CD. What I got today was what Mr. Glennie described as, he didn't actually describe it as an extraction report. He said very candidly and honestly, he said, I'm not sure what this is. I'm holding what appears to be a DVD. It has a item number or a DR number of 2017-102-483. I can tell you from my experience, and I'm not a tech guy either, but this is not my first rodeo. This is not a mirror image forensic copy of a cell phone. That usually is terabytes in size, and it usually requires a hard drive, a physical hard drive to put a phone on. This phone that I have, which is an iPhone 10 or an iPhone X, whatever you call it, probably would take up the better part of a multi-gigabyte, multi-hundred gigabyte hard drive. This, I'm guessing, Judge, is the extraction report from which they gleaned. Sorry, reverse that. It's the extraction report from the mirror image. We don't have a mirror image. And I will tell the court now, and I'll explain in some detail so the court understands why I'm troubled by what they do have. I need the actual phone. Their mirror image is not going to be good enough because their extraction report should be a mirror of their mirror image, if you will. It should be an exact copy of their copy. Here's why it's not. We know that Will Little deleted he, or apparently his mother, which was a place I never thought that we'd end up going. But he and or his mother deleted and manipulated the exculpatory texts that were on the phone. 100%. It's not a question anymore. It's absolutely clear evidence. The problem culminates in two issues. There were text messages that were between Will Little and his girlfriend at the time. We've designated her as MD. The DA had those text messages in their possession in the form of screenshots. When Will Little first went to the police, he provided them not mirror images, nothing like nothing techie. He just took screenshots of text conversations to support his argument that he was a victim of a crime. And he provided those screenshots to the police officer, to Trooper Donovan. I'm sorry, to State Police Officer
Kelly.
Not Donovan. That original set of reports was to Kelly. Kelly took those reports, and that was the foundation on which these charges were filed. The problem is those screenshots specifically had information missing. There were one-sided conversations, not the concomitant other side of the responses to those conversations. They never sought to find those. Then the DA also had in their possession, since November of 2017, a forensic report.
Yeah. He's got quite the... He had to cut himself shaving. Yeah, something.
From their download, or November or December of 2017, the forensic download. All right, so now that's the extraction report. They've got the screenshots, they've got the report. Here's the problem. Those two items don't match up. As a matter of fact, there's clear evidence that there were deletions by Will Little from the time he gave the screenshots over until the time Heather Unruh handed the phone over. Something was manipulated. We now know, because of this report supplied today, that at least Heather Unruh, at worst Heather Unruh and Will Little, both went through the phone and they cleansed it. They deleted information that they didn't want the police to have. They deleted information that they didn't want us to have. Here's an example, just a quick example for the court. At 1:41 a.m., there was a text, according to the forensic report, MD sent, and it says, quote, Will, leave and go home. Just those 4 words. The response was, should I actually? Question mark. Then the word help. Then the word picture. Clearly that was an indicator that he was questioning should he even leave the club at 1:41 in the morning. And he wanted to get a picture. With who? With my client. When he handed the phone over to the police, he deleted the entire message except for the word help. Their extraction report only shows help. Ooh. That's the kind of cleansing that Will Little and
I mean, we all know what it is. That is all bad. That is all bad. that case can get thrown out right now. I'm really interested in what the Commonwealth is going to argue. Too bad they don't have Hank Brennan's punk ass up there to lie and deceive. But this guy seems like he's not a bad cat from what I've seen of him so far. I might just go ahead, so that, like Alan Jackson said, that was pretty much the zenith of his argument. Let's get to the Commonwealths, because I want to do this in two parts. I want to do it these motions and these hearings in the first part, and then for the grand finale tomorrow, what I'll record is Trooper Gary Donovan's testimony and the alleged victim's testimony. I guess, yeah, there's some Fifth Amendment privilege invoked. And then Nick Little, he will testify. And then Nick Little's mom. Man, I would love to do it tonight, guys. I would love to, but let's just make this like a nice little 30-minute video, and then we'll do a part 2, and that's going to be amazing. And we'll get to talk all kinds of shit about everybody. Right? It'll be fun. But yeah, let's get to the Commonwealth's argument. I hate to miss any Alan Jackson. It's only 6 more minutes. Now let's get to the end of Alan's, and then we'll see where the Commonwealth comes in and see what they have to say.
And probably we're going to be able to get those, most, if not all, of those recovered texts. But I'll happily provide a more detailed explanation from someone who knows a lot more than I do in an affidavit to the court.
You do that.
I believe that this court should and must reconsider our request for Heather Unruh's phone and allow us to do an extraction or a mirror image of her phone as well to determine if there's exculpatory evidence, which we believe exists on her phone, still available.
And to that point,
or collusion.
In what period of time would you be looking to perform an extraction?
Well, it would start at July 7th, 2016, and probably go through the filing of the case in late 2018, December 2018, which is consistent with the time parameters that we've asked for Will Little's phone. Like, we're entitled to both. Just to let the court know, Mr. Glennie told me this morning that his position on the Trudeau communications is that we have everything. There are no other communications that are responsive to our request. If that is the Commonwealth's position, I would expect them to put that on the record as an officer of the court to state that. I'm deeply troubled by what has been happening and certain misrepresentations that have happened up to this point. But I'm going to stand above that, and I'm going to trust that anything that Mr. Glennie says about Mr. Trudeau's communications, it's true. It better be true. I can say that.
Well, I'm glad to know that there has been that communication, and my review of your pleadings and likewise Lenny's pleadings indicate that the Trudeau met with his sister in mid-March.
That's right.
It was fully underway at that point. So, I mean, it would be hard to, and Trudeau properly revealed that communication to the DA as he should. So it would be hard for the court to find that there was any bias in terms of our motivation to bring this case based on some communication that Trudeau had with his sister.
And certainly,
after the fact.
And certainly, if we get Miss Unruh's phone, which I'm hoping that we will, if there are communications going from her to Mr. Trudeau, it'll be revealed on that phone. So we'll see. But in the meantime, I take Mr. Glennie at his word. If there's no other communications, then I will table that issue and submit on that issue.
Thank you.
Thank you. First Assistant District Attorney on behalf of the Commonwealth. With respect to that aspect concerning Mr. Trudeau and his sister, the court should be aware, I'm sure there's probably just a statement, that there's no relationship between anybody in our office and Miss Unruh. The alleged relationship is with the sister of somebody in the office and Miss Unruh. So, and I would also state for the record, in the pleadings that I handed in today, I state again, that is the extent of what we have, which I've also attached to my pleadings today, concerning the issue of communications between Mr. Trudeau, his sister, or Mr. Trudeau and members in our office concerning that conversation he had in Miami, I believe it was on St. Patrick's Day, 2017. Your Honor, first of all, I'd like to suggest, what are we here for today? We're here for a motion that was filed by the defendant that was entitled Order to Compel Discovery Pursuant to Mass Rule Criminal Procedure 14 in Brady versus Maryland. And there are two things that were being sought in that motion. One is the phone information, and the second one was information concerning Mr. Trudeau. With respect to the phone information, Your Honor, if there's anything that can be gleaned from what we provided to the defendant today, that could certainly be subject to a motion subsequent to this. There's been no formal discovery motions filed in this case. Discovery is ongoing. The case is ongoing. There's been no conference report filed that says that discovery is complete or that we have any discovery at this point. Furthermore, when before the court issued its order, which I think we all.
Yeah, but you lied. You lied about discovery. You lied about what you had when you had it. Doesn't matter that discovery hasn't been filed, that they don't have all the discovery. It's an ongoing investigation. You fucking lied.
All understand the parties were not aware of until I think it was the 31st. Negotiations were conducted between Mr. Giardino and the defense counsels, I believe mostly with Ms. Little, concerning the turning over of what I call the forensic download. And that may not be the correct term to be using.
Would you call it the forensic what?
Download.
Oh, download.
And again, if that's not the correct term, I think we all know what I'm talking about is what's contained on that disk. We were under the impression that all that needed to be do was have that protective order signed. And if that had been done prior to today's date, that disk would have been provided before today. So the Commonwealth was willing to turn that over. Now, what led up to the point of us turning over more information, although not known at the time, but then the court has ordered the Commonwealth to turn over because the court's order is less than what we're willing to turn over. What happened is that Mr. Giardino, when before the court on April 4th, indicated that he was going through that forensic download, for the term I'm using, to see if there's anything that might need the court's intervention, if there was going to have to be some interaction by the court before that was turned over. The court was aware of that. Mr. Spacey's attorneys were aware of that. And then the court even asked Mr. Giardino, how much time do you think you need? He said, I think I can have it done by June. I don't believe there was an objection at that time made by the defense. The court didn't say that that was an unreasonable amount of time. He finished before June. He agreed that the Commonwealth should turn over the entirety of what we had in our possession. And that was done. That was done today. So what is it that the defendant is asking the court to order here when we've already turned it over and we're already willing to turn it over before this motion was even filed, known to the defendant? The second aspect of the motion was for the information concerning Mr. Trudeau in the conversations with his sister. The defendant was in possession of the answer to that, to an informal request for discovery again. In fact, that informal request, which is as an exhibit in my submission, had, I believe, 4 different things that they were asked. 3 of them were very specific, and 1 of them was not. The ones that were very specific were answered very specifically.
I saw that.
Given the information that was requested, the one that was a little more, I would say, overly broad, and the Commonwealth had some reservations about, the Commonwealth stated that. We have some reservations about this. The wording speaks for itself. It's in the switches. But so irrespective of that, here's what our answer is going to be. Now, if the defendant's not satisfied with that answer, that's when the court could become involved at a hearing. So I would suggest that they had that information as well before this motion was filed. Everything else, I would suggest, Your Honor, has to do with perhaps motions that may be filed down the line that really relevant to what this information is here. Now, I certainly understand that there was a report that was given today, and I can understand defense counsels wanted to bring up Ms. Unruh's phone, but that's fine. With respect to that, I believe that they would still have a right to appear and indicate whether they have any objections or whatever concerning that if the court were to deem that to be reopened. The suggestions that Mr. Giardino had made some statements, Your Honor. Now, this, I would suggest, really has nothing to do with what the motion was filed for. The motion has been answered in the sense they already have the phone information.
Look at AJ. AJ's taking notes, baby. He's taking notes. Do not fuck with AJ, dude. You're not going to beat him, bro. You're out there in some little island, Nantucket. You're not going to beat the man.
Already have the information concerning Mr. Trudeau's sisters, that conversation that took place. So the rest that's in the motion, I suggest, is just fodder for another day, not for today, not for this. If they want more specific answers, they haven't even looked at what was provided to them today, yet they're telling us what's on there or what's not on there. I think they need to look at that. If there's information that they feel we have that has been provided, they could ask for that specifically. We can answer. Either we have it or we don't.
I didn't get not of the opinion that they think you still possess information that they want. My understanding is that what has been provided, and you're right, they haven't looked at it yet, but it appears to Mr. Jackson that it's not going to contain all of what he needs, which he could obtain perhaps if he had the physical, the phone. So I don't think there's any indication that you're still holding on to anything with respect to the phone. It's just that what's been produced isn't going to be enough for him to sort through and get the deleted text. So
and that could be, again, fodder for another day. If there's a motion to suppress, a motion to
it doesn't have to be for another day. Another day is today, brother. Another day is today. It doesn't have to be for another day. And that's what I love about Alan Jackson. He doesn't file frivolous fucking motions, man. He just never does. He doesn't bombard the court with a bunch of motions to, throw up a smoke screen, to have some bogus defense. No, he's on facts. His motions are concise, they're articulate. He's a beast.
Dismiss?
Well,
Because
he's making a motion to get the phone, which he requested early on, and I, in a rather conservative approach, said, let's give him the extraction and see what happens from there. Go ahead, sir.
we don't have the phone.
No, I know. And now, I understand that. I see today that you don't have it. If that was revealed earlier, I wasn't aware of it, but I did see it in your pleadings. So.
But all I'm suggesting is that the motion that was filed, Your Honor, was answered, and all the information could have been provided had that protective order been signed and given to us prior to this date, before even being here today. And the rest of the information that's contained within that motion, Your Honor, I suggest was just an attempt to get their version of the case out before the media, which it certainly did do, as you can see by the attachments that I put in concerning the media attention to this. So the position of the Commonwealth is that there was no affirmative misrepresentation made by Mr. Giardino. If there were some misunderstandings between the parties, we certainly apologize for that. But we are attempting and have attempted from the beginning. If there's an issue, let's address it. If we need the court's available. That's what judges are for. If it's something we can agree to, let's agree to it. If we disagree on what we provided, we can take that to another step. The Commonwealth suggests, Your Honor, that this motion, number one, is not timely in that they have the information that they're requesting, and that the other things that they're asking for will be subject to another motion at a different time. With the understanding, I understand that that report was handed today, and that brings up issues concerning this unused fund. But everything else I would suggest, Your Honor, is already been taken care of. So I would move that I would ask the court to deny the motion for the reasons set out in the memorandum.
Thanks.
If I got caught like the Commonwealth got caught, I'd say it was miscommunication too. The best I can do. But it's absolutely not true. Mr. Glennie knows it. Mr. Giardino absolutely knows it. It's not a miscommunication. We were clear as a bell. We don't suffer from inarticulation. We told Mr. Giardino exactly what we wanted. We wanted information on the phone. We wanted everything that they had about the phone, and we wanted the phone itself. And his comment to us, it is not.
My hand to God, I haven't seen this. And he just said, we don't suffer from inarticulation. What'd I just say?
In our care, custody, and control. There's no other way to parse that. And I don't make these points lightly. It is not fun for me. This is not enjoyment for me. I don't like having to discuss an active misrepresentation by the people, by the Commonwealth on behalf of the government. I think it's outrageous. I think it's unjustified, and it's not fun. But it's also inherently not fair to us. And so Mr. Glennie's comments, he's doing the best he can to call it a miscommunication. There was no miscommunication. This was an active misrepresentation, and it should never, ever be tolerated, ever, especially on behalf of the government.
But what your motion boils down to at this point is that the Trudeau issue is off the table. What you're looking for is the phone.
Correct.
That's what this all boils down to, is you want the phone.
And at this point, given what we now know, and by the way, Mr. Glennie also says, well, they've got what they wanted. They've got this forensic extraction. They've got what they wanted. That's not true. Number one, we already know, and Mr. Glennie already knows, and he should be concerned that his extraction report is inaccurate. It is not an accurate representation of what's on that phone. How do we know that? Because of the group texts. There were group texts that they have in their file that don't exist in the extraction report. He knows that. I know that. So now we can all agree. Let's stop dancing around. We can all agree the extraction report is inaccurate. It has been manipulated. There have been deletions on it. Not by the government. That's not an accusation that we're making, but certainly by Heather Unruh or Will Little or both. So we need two things, Your Honor. I want the actual forensic download, which is not the extraction report from the download, but the actual forensic download. Colloquially, it's called a mirror image. I want the mirror image that Mr. Glennie and Mr. Giardino have currently in their possession. They do have that. Either them or at their crime lab, they've got it. Number two, the second thing I want is the actual phone. I'm entitled to go to the source data to find out what was or was not deleted. And that's what we're seeking. Those two things as it relates to the phone. The third thing is I want the same information as it pertains to Heather Unruh's phone. Now, I don't have a good faith belief that they've ever done an extraction of Heather Unruh's phone. So I don't think that exists or that they have it. So I would ask for her phone, for my expert to be able to do that forensic download or mirror image, so that we can then pull an accurate extraction report from that phone as well. That's what we're asking for. That's what we're entitled to.
Respect to that request, as Glennie indicated, I denied that request initially, and I know you want me to reconsider it.
I understand.
I'll take another look at it. If I decide that there's enough to pursue it,
Yeah,
it would have to be for the hearing. They would have a chance to come in and argue
That's
the
fine.
issue. So
that's fine. We accept that.
I understand. Okay, just so we're clear about
Yeah, I'm not trying to sort of overstep process. I get that there's a process.
Yeah, I'm all right. Fine. Thank you.
The last thing that I'll suggest to the court is as to the issue of timing. I brought this up at the last hearing. I'd like to address it again.
Sure.
Mr. Spacey is entitled to his speedy trial. Period and amen. What he is suffering every day that this goes on, every single day. There are cameras in the courtroom today. There are reporters populating the courthouse. Every day that this goes on without resolution is a day that he suffers. That's a day that he's not getting justice. That's a day that he's not getting his due process. The shenanigans that have been going on the government side are outrageous. They're unjustified. They're inexcusable. And we shouldn't have to suffer the ills of having to come back over and over and over. And every time we come back, we get something new and revelatory. There's a new revelation every single time we come back to this courthouse. That is not fair. That's not how the government should be conducting its investigation. That's not how it should be preparing for trial. If they weren't ready to go to trial on the day they filed this case, they should.
I see how he's smiling without smiling. I love that. It's because, you know why? Because he knows he has the best effing lawyer in the world. In the world.
Have filed it. And I submit they absolutely shouldn't have. This is a ridiculous case, and they shouldn't have filed it to begin with. But they did it. They unlocked that barn door, and now the horse is out, and they've got to go to trial. We're entitled to that. More importantly, Mr. Spacey's entitled to that. One of the things that I found it'd be amusing if it weren't so sad. In response to the motion that we filed, Michael O'Keefe, the DA, the sitting DA for the Cape and Islands DA's office, was confronted by a reporter who said, what do you think about these accusations concerning and the allegations concerning your office and misrepresentations that your office had made? His response was, if Mr. Spacey was not who he is, no one would care about this case. I know I learned a term in law school, gobsmacked. I was taken aback by that statement. That was ridiculous. For the sitting district attorney of this county to say if he wasn't who he is, nobody would care about this case. What is he saying? What's the translation? If it wasn't Mr. Spacey, he never would have filed the case? Is that the translation? Or is the translation, if it weren't Mr. Spacey, nobody would know about these representations. Nobody would know about holding back evidence because nobody would litigate this to the extent that we are. If they're not ready to go to trial, they shouldn't have filed the case. And if they think nobody cares about this case, my response would be to the Commonwealth, I'll tell you who cares about this case. We care about this case. Mr. Fowler, Mr. Spacey cares about this case. The people of Nantucket, they care about this case. If they don't care about it, so be it. God bless them. But we do, and we want a trial. And we're ready to go to trial. If this court were to grant us an expeditious discovery order today or in the coming week, I promise you, Judge, we will act expeditiously, equally expeditiously to get ready. No matter what that information is that comes to us, we just need the time to download it, analyze it, and then we're ready for trial. And we don't want to wait till October or November. We think we're entitled to a trial within 8 weeks or so.
Won't happen.
Why won't it happen, Judge?
The way things work here, and I appreciate that you're unfamiliar with them, is we have jury trials here every other month. And that's why I'm here this week. We'll have jury trials this week. The next trial session will be in August. There is a trial assignment date that occurs before that. And at that point, I set up the trials for that particular week.
Okay.
So again, this week, August, October, December. This case, I would expect, is not going to be able to be tried in one of the normally assigned jury weeks. I'm going to have to find separate space on the calendar to accommodate this case because, as you indicated that.
Sorry, Judge.
It's all right. You indicated that you thought it was going to carry on for 2 weeks. Maybe it will be because of the celebrity that attaches to it and the difficulties in selecting a jury. Maybe. I don't know. But the actual trial of these cases, similar such cases will take, maybe 2 days, maybe 3 days. It's not that complicated, at least from the court's perspective at this point.
I agree.
But in any event, I need to find, there are several other courts that use this space, the probate court, the superior court, the juvenile court, etc. So I need to be able to carve out that piece of time, and we're going to need to bring in more jurors than is normal. So if you're lucky, and I'm not being flip, if we're lucky, because I want to get the case tried too. I appreciate that it's a burden on him. But then again, every other defendant, and if you get in the queue, there are many ahead of you. It's likewise a burden to them, and some are in custody to have their case tried. So, I'm disinclined to let Mr. Fowler step in front of those people, except that there are considerations that need to be addressed in terms of a separate week.
And that's what I would ask. If the court could accommodate us in August, even late August.
No, it can't. At first.
And also, when he says Mr. Fowler, he's talking about Mr. Spacey. Kevin Spacey's real name is Kevin Fowler.
First of all, to try this case, I mean, it's difficult enough to get accommodations on this island anytime in June, July, and August. It would be it would be impossible, not next to impossible. It would be impossible to get this case tried.
I'll stay in a tent.
Well, I'm glad to know that. But
I get accommodations or lax, but we'll make do, Judge.
I appreciate it, but we have the issue of the jurors. As I say, we need to be able to summons them. That requires at least 90 days, etc. So it's just not an easy thing to accommodate. And as I say, Mr. Fowler, as much as I'd like to get his case tried for a variety of reasons, among them so that we can all move on to the next case, whatever, he's still one of the individuals who is in the queue. And I'll do the best I can, as I'm sure the Commonwealth will, to move this case along. It's not happening in August. Whether it can happen in October, November remains to be seen. But that's what you're looking at.
My co-counsel reminds me that, and I just want to bring this to the court's attention. I don't want to, the horse is, if it's not dead, it's on its last leg, and I don't want to beat it. But the court did indicate at our last, and this is new procedure to me, the court indicated at our last hearing that there's a possibility that the court might have, which is to set aside a special panel that's sort of outside the bracketed timeframes that the court might accommodate, if the court could at least consider that.
But even if, and I am going to do that, because
Okay.
I'm not going to do the best I can not to interrupt the flow of cases on this island. So I'm going to have to pick a separate space of time. But that still requires that we bring in jurors. That can't happen overnight. And so again, consider the horse dead with respect to a trial in August. So
I was hoping you weren't going to say that.
oh, sorry.
All right, Judge. I appreciate you at least listening.
Sure.
Thank you. Submitted.
All right. Anything else, folks, from anybody who's planning?
No.
Yes, and I feel I need to address a couple of things. One is really kind of a housekeeping matter, and I'm sure this wasn't intentional, but there was a mention made of the officer Kelly, and he was referred to as a state police trooper. Now he's not. He's
not.
man talking about.
That's my mistake.
Right.
Thank you.
And then, I would suggest that the Commonwealth, as I stated in the opposition, categorically denies that there was any affirmative, conscious misrepresentation at any time made by ADA GRD.
Understand.
And then secondly, Your Honor, there was some suggestion concerning about a media quote by Mr. O'Keefe. Now, I've had an opportunity to speak to him actually about that, and he was talking about the media, that the media wouldn't care if this was anybody else besides Mr. Spacey. Not that the people or the parties wouldn't care, but the media. And I think the court has seen that this is not the typical case in terms of the media interest. Not that there's anything wrong with the media being interested, but they are interested, and they're here hanging on every word. And I addressed the media in my submission, and I would just ask that you take a close look at that. Thank you.
Thanks, gentlemen. I appreciate it. I did indicate in my ruling that we could perhaps have a further pretrial if we're going to have one via video conference, if that would be helpful, I'm sure, to you, as long as we could orchestrate it. I would like an affidavit from your expert, if you can do that as quickly as possible. That would be helpful. And do you want to pick a further date at this point?
Your Honor, Monday the 8th seems to work with all of our calendars if it works with the court's calendar.
The 8th of July?
Yes, Your Honor.
Sure. Okay. Let's put it on for that date. All right, folks, thank you very much for your appearance here today and your arguments. I'll take it under advisement and hopefully can, as I say, issue a ruling later on this week, but I do want to see that affidavit.
We'll get it to you by the close of business tomorrow.
I appreciate it. All right, folks, thanks again.
All right. Okay, guys, there we go. That's going to be part one to my Alan Jackson extravaganza. We'll just call it. If you want, we can get a little. The next hearing is just motion hearings. I'm just going to kind of like look through it. I want to watch it right now with you guys so bad, but look, I'm going to do a second video. Make sure you guys come for that. Turn on your notifications if you're a subscriber. If you haven't subscribed and you happen to be watching this, why don't you hit that subscribe button, man? We have a lot of fun here at After the Bars. I try to do content every day. I have my daughter this summer during the days, so it's kind of hard to do my Mayhem show. But I do put out some content, and just hit that all notifications bell, and you won't miss a show. But the next show for sure is going to be a barn burner. I can't wait. It's going to be testimony, and it's going to be Alan Jackson doing the examination, the cross-examination, and he will not disappoint. He will not disappoint. So, whoops, I wanted to be like that. Yeah, Alan Jackson's not going to disappoint. So make sure you guys come check me out. I am Sam. This has been After the Bars. Remember, be kind to each other, be kind to yourself, and give yourself a little bit of grace. if you're just having a hard time, just know that when you're kind to others, it does help. It helps your own. I don't want to say depression, but it just helps your own. When you practice gratitude and you're intrusively kind to others, I don't know. My life just gets better. That's all I can say. Sorry that wasn't so succinct, but I think you guys know what I mean. All right, guys, have a good night. I am Sam. This has been After the Bars. Mahalo. And
Real Fabio.
yeah, oh yeah,
Yeah.
oh, I almost had the name. So he's like, yeah, that dude, he didn't testify against somebody on a murder trial.
There's a man named Sam who stands